This module explores the essential legal and professional responsibilities Arizona licensees must understand when representing clients in new home sales and developments. It ties together consumer protection principles, disclosure requirements, and case law that form the foundation of Arizona's new construction and subdivision regulations. When representing a client in a new construction or development, licensees must ensure that all statutory requirements are met before any transaction proceeds. This includes confirming the existence of a valid public report issued by the Arizona Department of Real Estate, ADRE, under ARS Section 32-2181, which provides buyers with verified information about the property's title, access, utilities, water supply, and development plans. A property cannot be legally advertised or sold without this public report, and any marketing must accurately reflect its contents. Handling earnest money requires strict compliance, depending on whether the property is an improved or unimproved lot. For unimproved land, earnest money must be held in a neutral escrow account until all statutory conditions are met, ensuring that funds are protected if the buyer chooses to rescind. Licensees must also follow specific contract disclosure requirements when earnest money is paid directly to the seller, including informing buyers in writing that their funds may not be protected by escrow safeguards. Understanding the public report's purpose and timing is vital. Advertising or promoting a subdivision before ADRE issues a public report is a direct violation of ARS Section 32-2183A and can result in disciplinary action under ARS Section 32-2153A16. Once the report is issued, all advertisements must display the public report number and identify the responsible broker. Buyers also hold key rescission rights under Arizona law. AAC R4-28-804 through R4-28-805. For improved lots, completed homes, a buyer can cancel a contract if they were not provided the public report before signing. For unimproved lots, buyers have 7 calendar days to rescind the contract for any reason after signing. Under ARS Section 32-2195.03. This cooling-off period allows time to evaluate the land's condition, zoning, and accessibility. Out-of-state subdivision sales carry an even longer rescission period of 6 months to protect Arizona buyers from distant or unfamiliar developments. The module concludes with critical Arizona case law on builder liability, emphasizing that builders carry an implied warranty of workmanship and habitability. Established by Columbia Western Corpus vs. Vela, 1979, and expanded in Richards vs. Powercraft Homes, Inc., 1984. This doctrine ensures all new homes are constructed in a skillful, safe, and habitable manner. Subsequent homeowners also benefit from this warranty, even if they were not the original purchasers. Builders may not easily disclaim this responsibility, as reinforced by Nastri EV Woodbrouse Homes, Inc., 1988, and they may face action from the Arizona Registrar of Contractors, ROC, for poor workmanship under ARS Section 32-1154. In short, this module demonstrates how Arizona real estate law prioritizes transparency, accountability, and consumer protection in the sale of new homes and developments. Licensees must act with diligence, ensure proper disclosures, protect earnest money, and guide clients through rescission rights and builder liability issues with confidence and legal accuracy. Key takeaways for study. A public report is mandatory before any advertising or sale of a subdivision. Earnest money for unimproved lots must be held in escrow and accompanied by full disclosure. Buyers of unimproved lots have 7 days to rescind. Buyers of improved lots may rescind if they did not receive the public report before signing. Advertising must reflect only approved public report information and include the report number and broker identification. Builders are legally responsible for workmanship and habitability, an obligation that extends to subsequent homeowners. Understanding these laws not only ensures compliance with ADRE regulations, but also reinforces a licensee's professional duty to protect clients and uphold Arizona's high standards of real estate practice. Module 6.3.2 Property Management, describing the special agency relationship as it relates to property management, one of the most complex and specialized fields within Arizona real estate, requiring licensees to understand and properly apply the laws governing agency relationships, fiduciary duties, and the handling of client funds. Unlike traditional real estate sales, property management involves an ongoing relationship between the broker and the property owner. This relationship is defined as a special agency, meaning the broker's authority is limited to specific acts outlined in a written management agreement. The Arizona Department of Real Estate, ADRE, recognizes property management as a licensed activity regulated under Arizona Revised Statutes Sections 32-2, 171 through 32-2, 176, and enforced through the Arizona Administrative Code, AAC, R4-2, 8-1101. Under Arizona law, a property management broker acts as a special agent to the owner, also known as the principal. This means the broker has the authority to carry out only those duties specifically authorized in the property management agreement, such as collecting rent, coordinating maintenance, hiring contractors, and managing tenant relations. The broker cannot sell, encumber, or materially alter the ownership interest in the property without separate written authorization from the owner. This principle aligns with the broader agency law framework outlined in Arizona Revised Statutes, Section 3215-3, and the fiduciary duties established under Arizona Administrative Code 4-28-1101, which require honesty, accountability, and full disclosure in all dealings. A property management relationship begins with a written property management agreement, as required by Arizona Revised Statutes, Section 3217-5. This agreement must specify the property being managed, the duration of the contract, the scope of authority granted to the broker, and the manner in which compensation is to be paid. The agreement also must clearly state how funds are handled, including the establishment of a trust account for the owner's money under ARS Section 32-2174. For example, if a broker collects rent payments from tenants, those funds must be deposited into a designated property management trust account and dispersed only according to the terms of the management contract. The broker holds these funds in a fiduciary capacity, meaning they must not commingle client funds with personal or business operating accounts. The special agency relationship is also characterized by the broker's obligation to act within the limits of authority granted by the owner. Suppose a property management broker oversees an apartment complex in Phoenix and decides to renovate several units without the owner's prior approval, unless the management agreement specifically authorizes such improvements. The broker has exceeded their scope of authority and violated ARS Section 32-2153, which prohibits acting beyond the terms of an agency agreement. This could lead to disciplinary action by ADRE and possible financial liability to the owner. Unlike general agents, who have broad authority to act on behalf of the principal, property managers operate under limited authority. They are empowered to make day-to-day operational decisions, but not to bind the owner to major legal or financial commitments. For instance, while a property manager may sign lease agreements with tenants on the owner's behalf, they may not refinance the property, sign a sale agreement, or enter into contracts exceeding the financial limits set in the management agreement. In Arizona, the property management broker also assumes fiduciary duties similar to those found in other real estate transactions. These include obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. For example, The duty of accounting under ARS, Section 32-2174, requires the broker to maintain accurate and complete records of all monies received and dispersed, including rent collections, maintenance expenses, and management fees. These records must be retained for at least 5 years, as required by ARS Section 32-2151.01a. The concept of special agency in property management also carries important implications for liability. Because the broker acts as the owner's agent, the owner may be held responsible for the broker's actions within the scope of the agency relationship. However, if the broker acts outside their authority, such as misappropriating funds or entering unauthorized contracts, the broker alone bears personal liability and may face disciplinary measures, license suspension, or revocation under ARS Section 322153. An illustrative example comes from the case Arizona Department of Real Estate v. Horn, 1993, where a broker managing multiple rental properties failed to deposit tenant security deposits into the designated trust account. Instead, the funds were used to pay business expenses. The court upheld ADRI's revocation of the broker's license, emphasizing the fiduciary duty owed to clients and the strict trust account requirements under ARS Section 32-2174. This case underscores the broker's special obligation to safeguard client funds and operate transparently within the terms of the management agreement. Review summary. Property management establishes a special agency between the owner and the broker, granting limited authority to perform specific management duties as outlined in a written agreement. The broker must handle all owner funds through a trust account, maintain accurate records, and act only within the scope of the agreement. This relationship requires strict adherence to fiduciary duties and compliance with ADRE regulations. Breaches of these duties, such as mismanagement of trust funds, unauthorized actions, or failure to maintain records, can lead to disciplinary action, financial liability, and loss of license. Discussion prompts. Why is the property management relationship classified as a special agency? Answer. Because the broker's authority is limited to the specific duties listed in the management agreement, such as collecting rent or arranging repairs. What must be included in a valid property management agreement under Arizona law? Answer. The agreement must specify the property, the duration, the scope of authority, compensation, and handling of funds. What is the consequence of commingling client funds with business funds? Answer. It violates ARS Section 322174, leading to disciplinary action and possible license revocation. Closing remarks. The role of a property management broker in Arizona requires precision, professionalism, and a clear understanding of agency law. By adhering to the statutory and ethical framework governing property management, brokers can protect their clients, maintain trust, and operate successfully in one of real estate's most regulated fields. The special agency relationship exists to define boundaries and preserve accountability, ensuring that all parties' interests are lawfully and ethically protected.